Good afternoon, everyone. I would like to thank Honorable Chair Dr. Conrad for having me in this panel. It is a great honor to be in the same panel with Professor Beku, Professor Felipe, and Dr. Dove Jacobs. I'm really sorry that I could not be physically present in this session, and at the same time, I'm grateful to Astrid and her wonderful team for ensuring my virtual presence. Today, I will be presenting on the experience of Bangladesh in prosecuting past atrocities on national level. And summarily, my discussion will focus on the historical background of Bangladesh and nature of genocide, the historical background of the International Crimes Tribunals Act of 1973, and the International Crimes Tribunals of Bangladesh. And I will summarily discuss on the nature of challenges we have faced, which include political challenges and international criticisms from different corners. So at first, the historical background of Bangladesh, which is, we all know that for 200 years, for almost 200 years, Bangladesh was part of the British colony. In 1947, two countries divided on the basis of religion. One is India and one is Pakistan, and Bangladesh was named as the East Pakistan of Pakistan. However, from the very beginning, there was this difference between the two parts of Pakistan. On the basis of language, it became very prominent. In 1952, language movement for the recognition of Bangla as a state language was staged, and 21st of February is now celebrated all over the world as the International Mother Language Day. This is the day when a lot of people sacrifice their life for the recognition of Bangla as a state language. Then from 1952 to 1958, there was political turmoil. There was no constitution for Pakistan, no rights for the citizens, including the religious and ethnic minorities, which included Hindus, Christians, Buddhists, and other religions as well. Excuse me. 1958 to 1970 was martial law, and uprising from discrimination upon the citizens of East Pakistan was so prominent that every year there was massive scale of protest from the citizens of East Pakistan against the discrimination that took place against them. It led to the 1970s national election. The Awami League, of which is the present government as well, the Awami League of East Pakistan, under the leadership of the father of the nation, Bangabandhu Sheikh Mujibur Rahman, had a landslide victory. However, military juntas declined to hand over the power to the elected government, and it all led to the War of Independence of 1971 on 25th of March through Operation Searchlight, which was conducted by the Pakistani army. Now, and also on 25th of March night, the father of the nation declared the independence of Bangladesh, and from that moment onwards, the War of Independence started. The principal perpetrators of that war was Pakistan Occupation Army, and the auxiliary perpetrators were leaders and activists of pro-Pakistan Islami political parties like Jamaat-e-Islami, Muslim League, NDP, etc. They formed Peace Committee, Rajakar forces, Al-Badr and Al-Sams and Al-Mujahid, and all these led to the killing of 3 million innocent people, and almost 3 million, and more than 200,000 women were raped, and more than 10 million people became refugees. All these sacrifices came to an end on 16th of December 1971 when Bangladesh was independent, and we celebrate that day as the Victory Day. Now, after 1971, there was this question of trying the perpetrators, both principal and auxiliary forces. What happened is that there were two acts were enacted. One is the Collaborators Ordinance, and one is the International Crimes Tribunals Act of 1973. The Collaborators Ordinance, I mean, it was primarily an ordinance. So the Collaborators Ordinance was cancelled, or I would say was declared null and void by the subsequent military after the brutal killing of the father of the nation in 1975. However, the International Crimes Tribunals Act of 1973 survived. So now this International Crimes Tribunals Act of 1973, which was enacted for the trial of both the principal and the auxiliary perpetrators was drafted by the then ICL international criminal scholars, and one of them was Otto Trifterer of Salzburg University. They placed the definitions of the crimes as per the development of the international criminal law at that time, which included Nuremberg trial, Tokyo trial, Genocide Convention, Geneva Convention, and etc. It was a perfect mixture of international human rights law and international humanitarian law. Procedural law was also included. And the name was, even though it's a domestic tribunal, but since it was trying international crimes, it was named as International Crimes Tribunals Act of 1973. Finally, after so long political turmoil, after the demise of Father of the Nation, I would say the killing of Father of the Nation in 1975, finally on 25th of March 2010, the first International Crimes Tribunal was established through the political will and national solidarity of the then Awami League leaders. Especially the Prime Minister of Bangladesh, she showed the political will and her stability to establish this. Later in 2012, second tribunal started its journey. The first tribunal was consist of 3 Supreme Court judges who were sitting in the High Court division, and the second tribunal was also established in that manner. Appeal lied to the appellate division of the Supreme Court of Bangladesh, which is one of the unique features of the tribunal, as you know, that no other tribunal has that option or had that option before Bangladesh. Now, what is the organogram of tribunal? It has a registrar's office, it has prosecution and investigation office, defense works there, and there is this honorable judges. Now, Office of the Registrar's Tribunal, it maintains judges' offices day-to-day activities of the tribunal. It consists of a registrar, who is equivalent to a district judge, a deputy registrar equivalent to an additional district judge, and 3 researchers equivalent to senior assistant judges. Section 7 of the International Crimes Tribunals Act establishes Chief Prosecutor's Office, which is consists of 1 chief prosecutor, and there are 16 other prosecutors who are appointed by the government under Gazette. Then there is investigation agency, which consists of 20 plus investigators right now, which is established under Section 8, and their responsibility is for investigation, keeping records of the investigation, communicating with prosecution witnesses, collecting documentary evidences, submitting investigation report to the prosecution, maintaining liaison with other law enforcing agencies, and witness protection. And the judges, as I said, they are from the Supreme Court judges sitting in this tribunal under Section 7, 11, 11A, and 20 of the International Crimes Tribunals Act. Now, what is the definition of complaint? How a complaint is lodged? Primarily, it means any information, oral or in writing, obtained by the investigation agency, including its own knowledge relating to the commission of a crime under Section 3, subsection 2 of the Act. This means a complaint can be made orally, in writing, or from its own knowledge. After receiving the complaint, they start investigation, or they stop it if there is no sufficient ground to continue it. Now, what the investigation process is quite elaborately described in Chapter 2 of the Rules of Procedure of this Act. However, they proceed in person to the spot. They investigate the facts and circumstances of the case. If necessary, take steps for the discovery and arrest of the accused. They interrogate the accused if he is in custody in the presence of his lawyer and a medical officer. They maintain the case diary. They present the progress report to the tribunal if required. Progress report every 3 months if the accused is in custody. Obtaining a warrant of arrest through a prosecutor is also his duty, and they go on for effective and proper investigation. They submit investigation report within 1 year if the accused is in custody, and they present investigation report, documents, papers, and any other evidences to the chief prosecutor at the end of the investigation process. So after receiving the investigation report, the chief prosecutor or any other prosecutor, they authorized by the chief prosecutor, prepare a formal charge in the form of a petition on the basis of investigation report, evidences, and other documents. Section 9.1 and Rule 18.1 describes about this procedure. Now, how do we prepare a formal charge? One prosecutor is authorized by the chief prosecutor, as I said. That prosecutor scrutinizes the investigation report, evidences, and other documents, for example, the complaint or the case diary. Prosecutor tests whether the elements of crimes under Section 3(2) are present or not. Prosecutor visits places of occurrence, talks with prosecution witnesses and other people to validate investigation report. Finally, the prosecutor submits formal charge to the tribunal along with investigation report, evidences, and other documents. A set of those are submitted to the defense without disclosing the photo of PWs and some other details for their safety and security. A formal charge and charges framed by the tribunal must contain name and addresses of the accused person, name and addresses of the witnesses, the date, time, and place of occurrence, such particulars of the alleged crime as are reasonably sufficient to give the accused person notice of the matter with which he is charged. If you want to go through, all the formal charges are online and you can go through them. Now, the proceedings before a tribunal shall commence upon the submission of formal charge. The tribunal shall, after scrutinizing the investigation report, formal charge and evidences, will declare the charges in the open court, and the accused, if present in the dock, will be arraigned. That is, he will be asked whether he plead guilty or not. After charge framing, a date is fixed for the initiation of trial. Generally, at this stage, the defense submits a discharge petition, and if the tribunal dismisses the discharge petition, then the defense will submit a review petition to review the order. Finally, after all these, the trial starts on the date fixed by the tribunal. Now, in the trial, prosecution submits a list of witnesses 3 weeks before the commencement of the trial, and defense will also submit a list of witnesses, evidences, and documents supporting their case within 1 week of receiving the list of witnesses from the prosecution. The prosecution shall make an opening statement, examination in chief and cross-examination will take place, and the defense lawyer is always allowed to cross-examine. If they are not present in the case, the trial adjourns. Prosecution may call additional prosecution witnesses and submit any other documents to the tribunal at any stage of the trial with the permission of the tribunal. Generally, prosecution sums up their case first, then the defense sums up their case, and then prosecution submits their reply on legal points. Now, there are 3 types of liability. One is individual, another is superior, and there is joint criminal enterprise. Joint criminal enterprise is defined under Section 4, subsection 1 and subsection 2. There are 3 types of joint criminal enterprise under these subsections. These are, as we know, as the direct joint criminal enterprise, presence in the hierarchy or the concentration camp related joint criminal enterprise, and then 3 indirect or constructive joint criminal enterprise. And the elements of these joint criminal enterprise are quite identical with those which we have found in Nuremberg and in other Tokyo tribunals, because till 1973 those were the only examples before the drafters. Now, regarding superior responsibility, we are talking about 2 types of superior responsibility. One is military and another is civilian, and there are 2 types of control. One is de facto and another is de jure control, and we can talk about Salahuddin Qadir Chaudhury's case, where we see de facto control of a civilian person, and in Ghulam Azam's case we see de jure control of a civilian leadership. Now, there is rules of evidence which is spelled out in section 19 and chapter 6 of rules of procedure. Burden of proof, to prove it beyond reasonable doubt, is on the prosecution. Only alibi is the responsibility of the defense, and there is no technical rules of evidence. Hearsay evidence is allowed only if the source is known. If there is no source of any hearsay evidence, then that evidence is not allowed. The collective memory is also considered as a hearsay evidence. Receiving a dead person's statement can be received as evidence if their statement is recorded by the investigation officer or first-class magistrate before they die and after the formal charge is submitted. Common knowledge and judicial notice both are also to be considered by the judges during trial. Now, judicial notice is in line with the norms of international criminal law. Provisions are similar to the provisions laid down in the ICTR, ICTY, SCSL, and ICC statute. Two kinds of facts can be taken into judicial notice. One is common knowledge, as we have seen in Caramera et al. Appeal judgment. Notorious facts of history, genocide, and crimes against humanity committed in 1971 are generally taken as common knowledge in our trial. Adjudicated knowledge of facts, that is also been decided in Caramera et al.'s motion decision dated 9 November 2005, which are facts decided in the court through judgment. Only the facts and knowledge those are recognized in Kader Mullah appeal judgment are so far regarded as the facts decided in the court through judgment in Bangladesh Tribunal. Now, in Kader Mullah's case, it has been said about common knowledge that we would nevertheless add that given the fact that the whole world knows what went on in Bangladesh in 1971, and given that it has been proved by evidence that the appellant committed the offense with a view to obliterate the war of liberation and the cherished aspiration of the Bengali people to attain liberation, in conjunction with Pakistani army, which was bent to crush that aspiration in a planned, premeditated and systematic manner through countrywide operation. It is axiomatic that the offences formed part of systematic and widespread operation, and hence the same stand proved anyway on judicial notice of fact of common knowledge. At this stage, I can see that I have already taken 16 minutes. I will take permission from the chair that I will need another 4 minutes to wrap up my discussions. As I said, we used hearsay evidence, and there are single uncorroborated witnesses, old evidence, and collective memory is also other principles that we are using in the trial. Now, section 20 is the section where the verdicts are pronounced, and under section 21, both prosecution and the defense can appeal to the Supreme Court of Bangladesh. The rights of the accused persons that they enjoy, that is the most talked about Bangladesh trial, that they don't enjoy any rights, but that's not true. Article 47.3 and Article 47A of the Constitution, even though those two articles of the Constitution says that they will not enjoy any fundamental rights under the Constitution of Bangladesh, however, they enjoy several rights, which are right to be presented by a legal counsel of accused's choice, appointing legal counsel if there is none, submitting a copy of all relevant evidence and documents before charge hearing, defense witnesses for alibi, cross-examination, health checkup, VIP facilities in the jail, comfortable secured vehicle for transportation, adjournments, review petitions under Rule 46A, and they are being tried by High Court judges, and right to appeal. Now, there are political criticisms that why Awami League started it after such a long time, due to their long-term, as I said, this is because their long-term mandate. Killing of the father of the nation in 1975 jeopardized the whole political scenario. However, this is not a political vendetta, because this tribunal has discharged a number of persons since there was no allegation against them. Even Awami League supporters are tried here as perpetrators. Prosecutors and investigators are working to bring the principal perpetrators to justice, even if they are in absentia. How long will it continue? Till the last perpetrator is alive. Now, there are certain fair trial questions. ICTPT has followed all the norms that are spelled in Article 14 of ICCPR. Provisions of the International Crimes Tribunals Act are compatible with the rights of the accused enshrined under Article 14 of the ICCPR, which includes Article 14.3a regarding providing information in a language he understands, corresponds with Section 10.3 of the International Crimes Tribunals Act. Article 14.3b regarding adequate time and facilities for the preparation of his defense and to communicate with the counsel of his own choosing. Article 14.3c regarding the right to be tried without delay corresponds with Section 11.3 of the International Crimes Tribunals Act. So you will see that all of them are quite identical with those you have in we have in Article 14 of ICCPR. Now, there is this question of retroactivity. Regarding this, I'll just say one sentence that critics generally refer to Article 15 sub-article 1 of the ICCPR, but they often forget about Article 15.2 of the ICCPR. Now, what Article 15.2 said? Article 15.2 clearly said that nothing in this article shall prejudice prejudice the trial and punishment of any person for any act or omission which at the time when it was committed was criminal according to the general principles of law recognized by the community of nations. We know that thanks to Nuremberg trial and Tokyo tribunals, that those crimes were already known to the whole mankind in 1971. Now, could ICC try this? No, we know that ICC cannot try the crimes that has been committed in 1971 in the War of Independence of Bangladesh. Now, I'll not go. I will not go any further because I know the time is running. I will just end saying that why any other international community should follow the Bangladesh model. I'll just end up saying that it's cheaper because the state is engaging national prosecutors and national judges. Then then it's cheaper, and then it's been tried under national law. It's tried under national law, so you will not need to hire international experts, which is the problem in ECCC. So saying this, I will conclude my my speech here. Just last note that so far 70% have been convicted. Right now 34 trials are running, 17 prosecutors are there, and 33 judgments have been pronounced by this trial. If you have any questions, I will be happy to answer them. And once again, thank you everyone for hearing this quite passionately. Thank you.